Hello to everybody tuned in right now from all over the globe. Thank you so much for joining us for another empowering session with the one and only attorney Sharif Silmi, where of course we'll be giving you more insights and helping you on how to achieve your very own US green card. Hi, Attorney Sharif.
Hi, Mary. Thank you so much again. And I hope everybody's doing well and excited to join you again today.
Yes, happy to be learning with you and of course with everybody. So I'm sure that everybody who's tuned in, you know that our topic for today is of course proven NIW strategies for STEM graduates and professionals. So of course everybody knows that I'm a proud member of the Silmi Law team, and I hate to brag, Sharif, but I believe since I joined, or at least definitely for the past few months, we've had 100% approval for NIW.
Yay.
Yay!
Thank you
Right, of
so
course,
much.
all because of Attorney Sharif and of course and his insight, his excellence, his experience, and everything. So, Attorney Sharif, is there a secret recipe? Maybe tell us how we have been able to produce 100% approvals, especially when it comes to our NIW clients.
Yeah, look, I think that folks need to understand that when it comes to a national interest waiver, there is a method to the madness. There are specific rules that need to be followed in order to qualify for the legal standard. And I think now is probably the opportune moment in time. When I think about national interest waiver, we've been working in this area for many years now, and I find that with the guidance that does exist right now from USCIS, the adjudication process, things are actually going quite well, and we can formulate a case based on one's abilities and education and record, such that it would definitely qualify. We have seen actually the opening up of national interest waiver to folks who are maybe a little bit earlier in their careers, as opposed to it, I think, traditionally being something that was reserved for those who may be in a like post doctoral situation, right? So like we've had a lot of success with national interest waiver cases, even for people that don't necessarily have a master's degree, right? So if we just kind of want to think about the very basics, what a national interest waiver is all about is that one is in a situation where they are applying for an immigration benefit without an employer for the most part, right? I mean, there are national interest waiver cases that are sponsored by a company or an employer, where a permanent labor certification is impractical. But at the same time, I mean, I think the vast majority of our cases have been self-petitioners. So where you have a person who is in a situation that they are completing their education in the United States, and they probably have an OPT, which is an optional practical training of usually 1 year, or if it's a STEM related, for multiple years. What you find is that they're like, is there enough time for me to even get a green card through the traditional route of having an employer sponsor me? What are my options? And those are the kinds of situations where we want to intervene and make sure that people are putting themselves in a position to ultimately succeed. And the national interest waiver is just an amazing tool in that regard, right? So it's someone who is an EB2 level category. In fact, I'm gonna do something. I'm gonna share my screen here, and there we go. So this is the analytical framework that was set out in the Dhanasar case, DHANASAR, for those of you following along at home, and understand that the analytical framework that exists under Dhanasar, it's one of the unique things about a national interest waiver, that it's actually based on case law rather than simply statutory rules like most other immigration related classifications. So you hear that, or you see here that even the case itself recognizes that there should be some flexibility to circumstances of both petitioning employers and self-petitioning individuals. So it really does emphasize self-petitioning individuals. And to be honest with you, I think those are the folks that we are most interested in helping and supporting. And you can be outside of the US. You might be in the US, like I mentioned, completing your education and are now in an OPT situation. And then you find under this framework, right? So here's the framework that exists. This was established in 2016, right? USCIS may grant a national interest waiver if the petitioner demonstrates by a preponderance of the evidence that they are meet these three requirements, right? Now, here's the thing that people don't necessarily understand. Before you even get into that analysis, right, regarding the three requirements that exist under the national interest waiver, you need to make sure that you establish that you are an EB2 level individual, meaning you are within the employment-based second category, right? So if you are employment-based second category, meaning you have a master's degree, a professional degree or higher, or you go through what's called the exceptional ability analysis, which is an E21 exceptional ability analysis. We've done a discussion on this, so people can look for the past video about EB1A success strategy. I'm sorry, NIW success strategies, and they will find that this E21 exceptional ability may allow an individual who does not have a master's degree to apply for national interest waiver under specific circumstances. Now, here, what it says is there are three requirements for a national interest waiver, right? That number one, the individual has a proposed endeavor that is of national importance and has substantial merit. It's all about proposed endeavor, right? That's the first requirement. Second requirement, that you are well positioned to advance the proposed endeavor. And then third is a balance test. And what's the balance test? It's a balance between whether the normal course of applying for immigration through a employer-sponsored petition is practical or is more beneficial to U.S. interests than the proposed endeavor that is in the present case. So the ultimate secret of national interest waiver approval is the proper and correct articulation of a proposed endeavor. If anybody is out there and they're working on their national interest waiver and they have not yet defined a proposed endeavor, or whoever's advising them has not even asked them about their proposed endeavor, they're in trouble. They're going down the wrong path. The national interest waiver is all about proposed endeavor. Now, let me tell you one thing, Mary. If you have a question, you could shoot in, but I'll tell you one thing that I think is really, really important. And that is that there's no list of proposed endeavors necessarily, right? It's not like you have a list from the government saying, here are proposed endeavors that are eligible for a national interest waiver. You, as the individual seeking to establish qualification under the national interest waiver, are able to articulate the proposed endeavor that you are seeking to undertake upon approval and entry, or upon maybe permanent residency in the United States if you are already in the US on a temporary worker visa. Now, the topic of today is what happens when we have STEM related folks who are interested in national interest waiver.
Although, sorry, Sharif, but very quickly, I was just thinking, because for many of our friends who, ask you the difference between NIW and EB1A, they feel sometimes it overlaps until they consult with you. Just for purposes of letting, people who would like to consult with you know, they've learned that your secret, right, to success we're also very successful with EB1A, but you as a lawyer, you really define their field of endeavor. Is that the same thing as with NIW? Because
I'll tell you the big difference between national interest waiver and EB1A, and that is that the national interest waiver is prospective looking, meaning you are well positioned to advance your area of endeavor, or actually your proposed endeavor, because you don't need to show that you have even fulfilled this endeavor yet, right? It's a proposal. Whereas EB1A, what they're saying is, I have a field of endeavor, right? Not a proposed endeavor. I have a field of endeavor that I'm already a part of, and I've already established myself as having achieved acclaim or notoriety at a very high level within the field that I am in. So that's what EB1A is talking about. National interest waiver is not talking about that. What national interest waiver is saying, I have a proposed endeavor. I'm going to propose something that I would like to do in the US, and I am well positioned to advance this proposed area that I'm seeking to establish myself in. So those are, I think, the
Mhm.
main differences in terms of national interest waiver versus EB1A. But there is
Very
overlap,
helpful.
no doubt. I think
Mhm.
that it's fair to say there's a great deal of overlap. Now, while I mentioned that there's no real list of professions that the national interest waiver, limits one to apply to, there is a special consideration that's given to STEM related folks. That is individuals who are in science, technology, engineering, and math. And so where this comes from, actually, if I could just share my screen one more time, so if we look at the actual adjudication manual, and this is the adjudication manual that is used by USCIS adjudicators, and it specifically instructs the adjudicators that there are specific evidentiary considerations relating to STEM degrees and fields, right? So, and then it goes on to say, the importance of progress in STEM and essential roles of persons with advanced STEM degrees is fostering progress, et cetera, et cetera. And these areas are important to U.S. competitiveness or national security, right? So we can make an economic argument or a national security argument. Now, it says to identify a critical and emerging technology field, officers consider governmental, academic, and other authoritative and instructive sources and all other evidence submitted by the petitioner. So they're not going to do the work for you. You have to be the one who makes the argument that your proposed endeavor falls within an area of critical and emerging technology. Now, how do we know if our proposed endeavor is going to fall within this critical and emerging technology list? Well, it's actually very easy, because our friends at the National Security Agency within the White House have listed it for us. So while this is not an exhaustive list of areas where one may qualify for a national interest waiver, if you are able to articulate, if one is able to articulate a proposed endeavor that falls within one of these areas: advanced computing, advanced engineering materials, advanced gas turbine engine technologies, advanced manufacturing. And you see that they're quite broad in a sense, right? So we can probably use some of these, definitions and fit many proposed endeavors within them. Advanced in network sensing and signature management, advanced nuclear energy technologies, artificial intelligence, quite broad, right? MLAI, autonomous systems and robotics, biotech, communication and networking technology, energy, financial technologies, so fintech. I mean, fintech folks who are out there. So you might be in, for example, outside of the US, working in fintech related technologies. Many folks from, Canada, Europe are applying for national interest waiver on this basis. There's a growing, obviously, fintech, market and industry in many Asian countries, West Africa, South America, all of these areas. If you're working in, fintech, you're working in any of these areas, we're doing lots of great work to help you and folks in your situation to achieve success through a self-petition. I mean, do you know what self-petition means? It means you do not need anyone to petition on your behalf. You can petition on your own behalf from anywhere in the world or from within the US. If you've completed your studies at a US education institution, that's obviously an advantage, and they want you to remain here. This is an entryway for those who have completed their education in the US. They don't have to wait around for an employer to pick them up and, suffer for many years. And because you know what employers do, Mary, it's, kind of a little bit, I would say, um, maybe unethical or maybe just kind of balance of power, is where they know that an individual is going to need a employer sponsor. Let's say they get them a temporary worker visa, like an H-1B. An H-1B is good for 2-3 year terms, right? So they'll let them, and you're stuck with that employer, or you have to transfer. They call it a transfer, but it's not really a transfer. It's actually a completely new H-1B application that would be submitted by a different employer if they want to change jobs. But if you're in that situation, right, you're probably like, oh, I don't want to take a chance and quote unquote transfer my H-1B to another employer. So I'm going to stay with this particular company. So what that company is going to do is say, oh, well, as a matter of policy, we do not sponsor, green cards within the first 5 years of employment. Well, it just so happens that they wait until the last year of eligibility on their temporary worker visa to then undertake the perm process, the permanent labor certification process, because only when you have that process completed and a immigration petition approved through an employer can you then either apply for a green card if your eligibility date is current, or apply for an extension of your H-1B beyond the initial term. So those are the situations that we're really, worried about, right? So using the self-petition is a way around all that nonsense. Now, there are countries like India and China where an EB-2 would not result in a short-term ability to file for a green card. However, most other countries, the dates are, they're backlogged, but they're not as bad as obviously India and China. So within a foreseeable period, you would be able to apply for a green card or a permanent residency, work permit, and everything based on the approval of the EB-2 national interest waiver. So looking at the various categories, right? So we said fintech, human machine, hypersonics, network sensor, quantum information tech. So these are the areas, right? Semiconductor, huge semiconductor cases all over the place. So, recently we completed a case where a gentleman was just not even like, we prepared his case before he even finished his master's degree, finishes his master's degree, is awarded the degree. The main experience they had was not even related to, any kind of permanent employment, and we're able to get them approved for national interest waiver because of the way we position the case, because of the arguments that we make, because of the understanding of what is required under the case law, mainly Dhanasar, and what the USCIS adjudication policy is. We can make sure that the case fits within that framework before even moving forward with it. So we're very confident in these cases in terms of what we're able to do. So really, really important is the critical and emerging technology list, and also understanding where that sort of lands folks, right? So it goes on to like explain in more detail, kind of like subcategories within advanced computing. And we should probably link to this in our videos so that people can look it up for themselves, because a lot of people out there, unfortunately, again, like more predatory practices, right? It's like they want to deal with low information clients. We don't do that. I mean, I think most of our clients are very well informed, high information people who, we like to give them the information at their fingertips so that they could go out and make an informed decision and know what it is, right? Know how exactly you do that, right? So AI, we talked about ML, AI, deep learning, reinforcement learning, right? Next generation AI. I mean, a lot of these are a little bit ambiguous. I mean, again, it's a pretty solid list, but you could definitely make arguments within these various descriptive terms. And a proposed endeavor, just to be clear, like, for example, if I say my proposed endeavor is to undertake, the development of machine learning in the US, right? That's not the way that you present a proposed endeavor, right? You have to be more specific. You have to be very detailed. You have to kind of go into it in lots of detail and argument and back it up with facts and evidence and such. So you might have a 1 or 2 sentence articulation of a proposed endeavor, but ultimately it's going to necessitate further development and review if you are to be successful with demonstrating that you are working in an area, you have a proposed endeavor in an area that is of national importance and substantial merit, right? So that's sort of the approach that we're thinking about when it comes to these specific STEM related lists. But again, we're not talking about a list that is completely and totally exhaustive. Rather, it's a kind of an introduction. And this is, again, critical and emerging technology is really one such list that the adjudicators can refer to and that we include. There are others as well. So, you know, this really kind of talks about it in terms of, so the list of critical and emerging technology subfields published by the Executive Office of the President, by either the National Science and Technology Council or the National Security Council, are examples of authoritative lists, right? So it's not an exhaustive list. And then officers may find that STEM area is important to competitiveness or security. For example, when the evidence in the record demonstrates that an endeavor will help the United States to remain ahead of strategic competitors or current and potential adversaries. Oh my goodness. I love making these adversarial arguments because, you know, I'm a political junkie in a sense, and you know, international relation background and such. So I really enjoy these cases a lot, if you can't tell already. So, you know, those of you who are interested in just, you know, learning more about national interest waiver, if you're outside of the US, or if you are studying in the US, or maybe are kind of just like stuck in limbo, you don't really know what you want to do. We have, you know, many people, whether, you know, from all over the world that are really taking advantage of the national interest waiver. I would say one of the fastest growing areas for national interest waiver interest is going to be, you know, from folks in, you know, West Africa and now South America. I'm seeing a lot of that. So we'll, you know, continue to kind of, you know, see growth in those markets and folks, because, you know, the world obviously, you know, it's interesting about US immigration law. I think that it's true of, you know, no matter what kind of area it is, and I'm done sharing with regard to the screen, but, you know, when it comes to a lot of these different sorts of immigration petitions, you kind of need this entrepreneurial spirit of, you know, being a self-motivated individual in order to succeed, in order to kind of advance yourself. And that's what America's really looking for. I mean, those are the people that come to this country and really, you know, make a difference and advance, you know, things forward.
That's very true. Thank you so much, attorney, for that wealth of insight and wisdom. We actually have, speaking of business, we actually have one of our viewers here, one of our friends, Mr. Abu Bakar. He would like to ask you, Attorney Sharif, as a postdoctoral who also has a business in another country, is NIW as an entrepreneur or as a researcher better for me? As a researcher.
You know, some people I think have so many, you know, qualifications and, you know, are at such a high level in their careers that you could kind of go any path. But it's a great comment, because so here you have I think what the question is saying is, if you are in a STEM related field, right? If your proposed endeavor is STEM related, and at the same time you are an entrepreneur, what do we do in that situation, right? Because it's a great question, and I'm sorry, I think to answer it, I'd like to just share one more time, because if we look at the actual guidance on national interest waiver release date policy that came out here, what it talks about is that the USCIS, so when it talks about the order that established the changes that took place, and this was the beginning of 2022, it says USCIS is clarifying how the national interest waiver can be used by STEM graduates and entrepreneurs, right? So then when we look at the actual policy memorandum, so they have this whole section on STEM related folks, right? Well, guess what happens when you go after it, right? Keep going down, and we're going to get to a point where, well, maybe it's not right here. Actually, it might be above it, where it talks about, oh, here it is, specific evidentiary consideration for entrepreneurs, right? So again, both individuals, and I just wanted to show that really quick. Both folks, whether you're a STEM related or whether you're entrepreneurial related, you are in great shape. So I think that to Mr. Abubakar's question, I would say that, you know, a postdoc who's in STEM related category and also an entrepreneur has a great case. So, you know, sleep well at night.
And now, thank you so much, Mr. Abubakar, for that wonderful question. So a while ago, attorney, you shared that one of our valued clients, of course, before he even finished the degree, we already attained the NIW approval. So there's no question there, right? You know, you can be still be in your field of study while you apply for your NIW. But as far as on the entrepreneurial side, is there like maybe you have to have your business established for 1 year, 2 years, 10 years before you can file the case for them, before you can make a compelling case as an entrepreneur? Is there like
You
a
know,
number of years?
there's not really a number of years, but one of the requirements under being well positioned to advance the proposed endeavor is that you have a track record of success in the area of proposed endeavor. So if you have a proposed endeavor that, you know, we're going to start a consulting firm in order to you know, undertake a certain science related activity, right? You can't just say like, well, you know, I'm a student and this is my dream and I'm, you know, a dreamer and, you know, nothing can stop me, therefore I'm going to start this business and be successful at it. That is, it can't be pie in the sky. You know, it's got to be sort of related to some actual bases in reality. So you have to have a similar track record of success. Now, that similar track record could be that, look, I was working in an organization and I learned quite a, you know, a great deal of information, and, you know, therefore I now feel confident to establish my own organization or my own entity. A better argument is that I have a similar company in another country. But yeah, I mean, I think that you definitely need to have some track record of success from an entrepreneurial perspective in order to demonstrate that you are going to be successful. Now, at the same time, you do not need to show that you will ultimately be successful, right? Like this is a proposed prospective case. So, you know, you can't really ascertain 100% that, you know, I am absolutely going to be successful. You know, and the adjudicator is not expecting that, but they are expecting you to be well positioned in order to advance the endeavor that you're seeking to establish. So it's not like it's a foregone conclusion. And, you know, I think sometimes sometimes I kind of hesitate to tell people what our approval rates are, because, you know, what happens is they're like, well, submit my case, because it means if you submit my case is going to be approved. Well, that's not how it works. We're not sprinkling magic dust on these cases, right? The reason why our cases are approved is because we know that they meet the standard before we submit them. We're not in the business of submitting cases. We're in the business, and I've said this before, of having cases approved. So that is the real basis, is we know what it takes to get to that level of approval. And it does require a great deal of patience on the part of the individual applying and getting us a robust amount of evidence that will enable us to have it approved. It's not like, you know, I don't want to make it sound easy, because it really isn't. It's a testament to the team's efforts and our efforts, and that we're able to get it done. But that comes through extremely hard work of our clients, first and foremost, and ourselves, in making sure that we're meeting that very difficult and, you know, heavy standard. So, you know, that's what we're, you know, really thinking about and engaged in here.
Yeah, speaking of clients, we have one of our hardworking, very kind clients. Hi, Mr. Parampreet. He's just greeting us. Maybe he has a question. Mr. Parampreet Singh. Thank you so much for trusting Silmi Law. So I think we're over 30 minutes, Sharif. So thank you so much to everybody who've been trusting us. And to those who are reluctant, please, I encourage you to please undertake that consultation. You can email us at info@silmilaw.com, or you can just book your own consultations by yourselves at www.silmilaw.com. So anything else you'd like to share, Attorney Sharif?
No, just that, thank you. I appreciate you, Mary. You're, always amazing and wonderful. And, I really just want to thank you for everything that you do. So thank you so
Oh,
much.
thank you. Thank you so much, Attorney Sharif, and to the rest of our amazing Silmi Law team. I guess that's it. Thank you. And please watch out for our next videos. Have a nice day, everyone.
Bye bye.